This regular webinar series covers different intellectual property topics and provides information about the latest development at the USPTO. I am Lead Judge Georgiana Braden from the Patent Trial and Appeals Board, and I'm thrilled to be here today with the Chief Judge and Deputy Chief Judge of the PTAB, because they're going to teach us all about the PTAB and give us information about the board's priorities under the new administration. Chief Judge Scott Bullock joined the board in 2007. Prior to becoming the Chief Judge, he served as an administrative patent judge, a lead judge, a vice chief judge, and deputy chief judge. So he knows everything that the judges do, and he knows how we do it. Before joining the USPTO, the chief was a patent attorney with the Department of Navy, a lawyer with the law firm of Fish and Richardson, and a law clerk to the Honorable Judge Alvin Shaw at the United States Court of Appeals for the Federal Circuit. The chief has a master's degree in systems engineering and a bachelor's in electrical engineering, both from the University of Pennsylvania. He began his career in the office as an officer in the U.S. Navy, after which he earned a law degree from Georgetown Law, where he was editor of the Georgetown Law Journal. Joining the Chief Judge today is Deputy Chief Judge Jackie Wright Bonilla. The Deputy Chief joined the board in 2012. Prior to becoming Deputy Chief, she also served as an administrative patent judge, a lead judge, and a vice chief judge. Before joining the USPTO, the Deputy Chief was a partner firm of Foley and Lardner, and she also served as a law clerk to now retired Chief Judge Rader at the Federal Circuit. The Deputy Chief graduated from the University of Virginia Law School and holds a PhD in pharmacology from the University of Virginia and a bachelor's degree in biochemistry from UC Berkeley. Thank you both so much for being here with us today. Now, before we get started with the presentation, I'd like to go through some basic housekeeping issues. First of all, this webinar is being recorded, and the video will be posted to the events webpage at uspto.gov. Second, please note that the chat box and the Q&A box do not work for this webinar series. Rather, you need to send all of your questions directly to us at the email address that you see right now on the screen. That is usptohour@uspto.gov. Now, you may see some items posted in the chat box, such as how to access closed captioning, but we cannot see or receive your questions through the chat box or the Q&A box. The only way we can get your questions is via this email at usptohour@uspto.gov. So send us your questions. Even if we can't get to them during this presentation, we will still endeavor to respond to your email. Now, without further ado, I give you Chief Judge Scott Bullock.
Thank you very much, Georgiana. So welcome, everybody. Thank you for attending today. As was suggested in the title slide, today we're going to be doing an overview, or a basics, if you will, about the Patent Trial and Appeal Board. We'll just start out with an overview, then we'll talk about appeals, then trials, and end with some of the priorities of the PTAB this year. So the first slide that you're seeing here just shows you where the PTAB sits within the U.S. Patent and Trademark Office. You can see that there are actually two boards at USPTO. There's the PTAB, we handle matters in the patents area, and also the Trademark Trial and Appeal Board. They do trials and appeals in the trademark area. We have, of course, the Patent Examination Corps that examines all of the patent applications, and in trademarks, they examine and register trademarks. So now you sort of see where PTAB fits within the overall agency. We go to the next slide, please. So, well, what is the PTAB? We are a neutral administrative body. We decide cases in two different areas, as you will see. And The current version of PTAB, the PTAB itself was created by the American Invents Act and came into being on September 16th, 2012. Previously, the PTAB was known as the Board of Patent Appeals and Interferences, and the board actually has a long history going back to the time of President Lincoln in the early 1860s. Next slide, please. So at the PTAB, the decisions are issued by administrative patent judges, and then there are 4 statutory members of the board. So as indicated here, we have just under 200 judges. We just go to the next slide, please. There we go. We have 5 offices. The Alexandria campus is our largest office, and then we have offices in Detroit, Dallas, Denver, and San Jose, California. And each of those offices has a hearing room where we can have in-person hearings. We'll talk more about hearings later. We can also do virtual hearings. The administrative patent judges are required to be both legally and technically trained, and they have extensive experience in patent law, and they come from a number of different sources. There's no one path to becoming an APJ. They've come through the examining corps, also from law firms, in-house counsel, and other government agencies, such as the Justice Department, ITC, and others. The 4 statutory members are the director of the USPTO, the deputy director, and the 2 commissioners. So they also are able to serve on cases and are members of the board. Go to the next slide, please. So as I indicated before, there's really 2 main functions that the PTAB does, and it is in the name. So we decide ex parte appeals, which are appeals when a patent applicant is dissatisfied with a patent examiner's rejection of their application. They can appeal under certain conditions to the PTAB, and we also conduct proceedings under the American Invents Act. These are issued patents that are challenged by third parties before the agency. Next slide, please.
Well, and I will tell you, Chief, that we have received some questions already from the audience, but I think several of them actually may be answered in this next section.
Okay.
So I'm going to hold off asking them just yet. But as a reminder to everyone in the audience, if you have questions, we can't see them from the chat box. So please send them to usptohour@uspto.gov. So Chief, would you like to take us through the basics of ex parte appeals before the board?
Yes, so the ex parte appeals, if we just go to the next slide, happens, as I mentioned, during examination in the prosecution process, where the examiner may reject a patent applicant's application. If there are, if the examiner has twice rejected the claims, or what's known as a final office action has been issued, then the applicant can seek review by the PTAB. There are other avenues that the applicant can take at that point, such as a request for continued examination. But at that point, an appeal is one of the options that the applicant has. I should also point out that the appeals are not only from applications for, initial applications for a patent. We also hear appeals from issued patents that are going through reexamination or reissue. But for the ex parte appeals, which are the ones, this is the bulk of our work from just original examination. It starts out where the applicant files an appeal brief, then the examiner will file an answer, at which point the applicant can file a reply to the examiner's answer. It's not required, but that it can be filed. And once a appropriate forwarding fee is paid and the case gets docketed, it goes to a panel of at least 3 patent judges to decide the case. And again, statutory members could also be paneled. So this shows a little more detail on this. I do believe the slides will be made available, so I won't go into too much detail other than to say that there are a few places where in order to advance the appeal, the applicant needs to pay a fee in order to keep the process moving. The final fee is the appeal forwarding fee, which will then get it over to the PTAB, get the case docketed, and then if a hearing has been requested, we'll conduct a hearing. If not, then the judges will just decide the appeal based upon the documents already in the record and issue a decision. So we go to the next slide, please. This slide just illustrates some of the sources that the board uses in deciding the appeals. Of course, we're bound by the law, case law from our reviewing court, the Federal Circuit, as well as the U.S. Supreme Court. There is a statute in 35 U.S.C., and we have rules for appeals in part 37 CFR, which stands for Code of Federal Regulations. Part 41 deals with appeals. The PTAB has precedential decisions that are binding on the board, and the director also issues guidance and memoranda that are binding on the board. If we go to the next slide, please. Now, when an appeal comes to the board, there are a number of possible outcomes, including what's called an affirmance, which means that the examiner's rejection on all of the claims are upheld. There's a partial affirmance where the rejection of at least one claim, but not all of them, is upheld. And then there's a reversal where none of the examiner's rejections are upheld. The board also has the option to enter what's known as a new ground of rejection, where the judges on the panel can issue a new rejection in addition to what rejections the examiners entered on one or more claims. So next slide, please. This is just a graphic of the overall process. You could see at the top, it starts with the examiner, and after a rejection, either a final or being twice rejected, the board takes the case. If the board reverses, in other words, overturns the examiner's rejection, it goes back to the examiner, who has a choice to issue the patent or continue prosecution and perhaps enter further rejections. If the board upholds or affirms the examiner, then the applicant has a choice. They can appeal to the U.S. Court of Appeals for the Federal Circuit, or they can also take that to the U.S. District Court for the Eastern District of Virginia on Section 145 of 35 U.S.C., which stands for United States Code. So that's the entire process there for appeals. Next slide, please. After an appeal, so the steps, of course, depend on what happened. If the examiner's rejection is affirmed, as was mentioned, then the applicant takes the next step to appeal or look for further prosecution. An affirmance in part, again, the applicant may choose to take the next step. And if the examiner is reversed, in other words, overturned, it goes back to the examiner for the examiner to take the next steps. Next slide, please.
Well, excellent. So as I mentioned earlier, we have received a couple of questions, and I wanted to pose a few of them to you right now. First of all, and this is for Deputy Chief Bonilla, how often are requests for rehearings granted in ex parte appeals before the board? And what are your top 3 suggestions for success in a request for rehearing?
Great, thanks for the question. In terms of how often the requests are granted, for ex parte appeals, the board typically denies about 85% of the requests for rehearing. They grant it about 12% of the time and grant in part about another 3 or 4%. So it's not inconsequential for them to be granted, and it is worth doing if you think it's worthwhile. And just as an aside, we see similar numbers in AIA proceedings and requests for director review. I mean, for example, as it relates to director review requests, we see about 80% of them denied, about 7% of them granted, and the rest of them are either pending or non-compliant or withdrawn. And I also wanted to point out that ex parte cases are not subject to director review. That's available in AIA cases. Instead, the director review may convene what's called an appeals review panel, sua sponte, to review a decision of an ex parte appeal or a reexamination appeal or reissue appeal. And at this time, parties can't request review by an ARP. It's only done sua sponte by the director. And by default, the ARP is comprised of the director, the commissioner of patents, and the chief judge of the board. And since its inception of ARPs, which was in July of 2023, there's been one ARP decision. So that's where we are on that. And that was one, interestingly, that affirmed in part and reversed in part, and the Federal Circuit ended up affirming the part where we were finding where the part of the decision the applicants failed to provide adequate written description. In terms of success for filing requests for rehearing, I know some of this may be obvious, but make sure that you explain with particularity how the board apprehended or overlooked something. This is actually required by our rules. So simply re-arguing your case is not likely to be effective. You really have to show how the board misapprehended or overlooked something. And also remember, you can't raise new arguments or cite new evidence for the first time in a request for rehearing. There are some limited exceptions, but generally you can't do that. The limited exceptions include, for example, the board or the Federal Circuit just issued new precedent, or the board raised a new ground of rejection in its decision. But generally, those are the only times. The other thing is too, and this is just good advocacy generally, is really present your strongest arguments first. Sometimes, and making sure you don't dilute out your strong arguments with your weaker ones. Really, hammer home with your strong ones and lead with those. And when arguing that there's an error by the board, always give your reasons of support. So cite to the record, use pin cites, whether it be prior art or affidavits or declarations from experts. And also cite, if it makes sense, to case law and support. So if you're aware of case law, such as a previous decision of the board or the Federal Circuit that supports your position, explains how that case law applies to your facts and shows how the board erred as a result.
That's excellent. Thank you very much. And now we have a question for the chief. We've got several folks who want to know, do they need an attorney in order to be able to appeal their case to the PTAB? Or can they do it themselves?
Thank you for the question. The answer is no, you're not required to have an attorney to an appeal, an examiner's rejection to the board. And in fact, with a limited exception, an applicant can represent themselves, which is also known by the Latin pro se. In other words, without an attorney, they're just doing it themselves. However, they also can choose to be represented by a patent agent, somebody who's passed the USPTO registration exam, but who is not an attorney, or a patent attorney and they've passed the registration exam and are an attorney. So any of those combinations, you represent yourself, have an agent or an attorney. All of those are perfectly fine. The exception is if you happen to be a corporation, if you're incorporated, or what's known by the fancy term of a juristic entity, then you have to be represented either by an agent or an attorney. Companies can't represent themselves. There's some relevant rules in the Code of Federal Regulations under part in 37 CFR. It's Rule 1.31 and 41.37 C1 are the relevant rules here for the appeals. I will say that, and as you saw from our brief introduction, there are a lot of procedures to be followed. It can be somewhat complex. So, you may want to consider seeking the advice of a registered practitioner to make sure that you're complying with all of the rules and requirements. The USPTO website has a list of registered patent attorneys and agents. So you can go to the USPTO website and find an agent or an attorney if you don't happen to have one already.
All right, fantastic. Now, Deputy Chief Bonilla, would you mind walking us through the basics of proceedings under the AIA?
Sure. If we go to the next slide. So one question might be, what did Congress intend when it created the AIA proceedings? This is what happens in the American Invents Act in 2012. And the idea was to increase the integrity of the patent system by having a vehicle to confirm the patentability of issued patent claims and removing unpatentable claims from the marketplace. It also is intended to act as an alternative vehicle for third parties to challenge a patent, alternatives to for example, expensive district court litigation, to create a streamlined, efficient, and cost-effective proceedings. One thing to keep in mind is the difference between litigating in district courts and adjudicating before PTAB. District court litigation addresses infringement, money damages, injunctions, validity of claims, and they are often large cases with very large records, and they're very expensive with really very expensive discovery. And those cases can cost multi-millions of dollars, and their average time for completion is 2 to 3 years. And by contrast, the AIA proceedings, they only address patentability of claims. You can also amend claims through a substitute claims and a motion to amend. We'll talk about that a little bit later. And it's not cheap either, but it is cheaper by an order of magnitude. It's generally into hundreds of thousands of dollars as opposed to multi-million. And the time for completion is about a year after institution. And also, as Chief Judge Bullock mentioned, all of our cases are decided by administrative patent judges with expertise in complex areas of the technology and the law, and these are often very complex. And by contrast, in district court, they're often decided by juries with no particular technical background or legal background. And also the judges themselves, while they're certainly legal scholars, they won't necessarily have the technical background in the cases themselves. And then lastly, it's to provide, fast resolutions of the cases. By statutes, the board they generally decide whether to institute a trial within 6 months, and they reach a final written decision within 12 months of institution. So we can go to the next slide. So what kind of proceedings that do we have? I know people who are relatively sophisticated will know this, but our audience may include people who aren't that familiar with our proceedings. So the first one is a post-grant review, or what we call PGRs. These are filed within 9 months of issuance of the patent. And in these cases, a petitioner can challenge the claims on nearly any ground, not just prior art. For example, they can challenge for lack of enablement, lack of written description, or ineligible subject matter. And today, PGR filings, the ones that happen in the 9-month window, there's about 4% of our AIA filings. We also have what's called inter partes review, or IPRs. These are filed anytime during the life of the patent, as long as it's 9 months after issuance. And those challenges are more limited. They can challenge claims as obvious or not novel or anticipated based on certain prior art. This is patents and printed publications. And today, about 96% of our AIA proceedings are for IPRs. And so those are the most common ones and the ones that you hear about the most. Under AIA, we also had what were called covered business method reviews. Those are no longer really something we do anymore because they sunset a while back. So, but we also have something called, it's on here on the screen, derivations, and we won't go into too much detail about those because there aren't that many. But basically, under the AIA, a first inventor to file system, one can assert that even if somebody filed an application first, they derived the application, the invention from the true inventor who filed later, who deserves the patent now. So those are the different ones that you see. If we go to the next slide. So who can file an AIA proceeding or petition to get the thing started? The first one is these can be initiated by almost anyone. People, businesses, and entity, but they can't be initiated by the patent owner itself. And also under Supreme Court precedent, the US government can't do it either. And as mentioned here, certain people and corporations may be barred from filing based on certain actions they take. I won't go into details here, but one example would be that you actually have to file a petition within 1 year of being served a complaint of infringement. And if you don't do that, then you're barred from filing. Next slide. So who's involved? The first one is a petitioner. This is, as I mentioned, is a third party, anybody who's not the patent owner or the government. They file an AIA petition that challenges the patentability of claims, and they also must pay a fee. And one thing to keep in mind is that petition is what we call the case in chief. So they need to have all their arguments, grounds, evidence, such as prior patents and printed publications, as well as the expert testimony as it relates to all the matters on the merits. So this is actually different than what you see in a complaint in a district court where they wouldn't necessarily have all of that in there. The patent owner, the petitioner carries the burden of persuasion throughout the proceeding. And they are often there. The reason why they're filing an AI petition is because they've been sued for infringement in district court. About 80% of the petitioners that we see have actually been sued in district court, and that's usually what triggers the AIA petition in the first place. You see that another party is obviously the patent owner. They have the ability to respond to all papers with its own briefing. And in every case, they're like all of our cases, they are decided by a panel of three APJs that preside and renders the decision. So just quickly, how do they work? I mean, what you see is a briefing schedule for 2 phases of the AIA proceeding. So in the first phase, which is called the institution phase or the preliminary phase, this is before the PTAB decides whether to institute or not. So what you see here is petitioner files a petition. The patent owner can file what's called a patent owner preliminary response if they want to. They don't have to. There may be a reply and surreply in certain circumstances if requested, and then the board issues a decision on institution. And we'll talk a little bit more about it later. But when you hear about what's called discretionary denials or FinTIV and things like that, they take place in this first phase. In the second phase, if the PTAB institutes, then there's what's called an AIA trial. And that's what you see, the trial phase. And during this phase, a patent owner files a response, and if it wishes, it can file a motion to amend claims. And thereafter, you see there's a series of responsive briefing back and forth. And another thing that goes on during this phase is discovery. Now, it is more limited than what you see in district court litigation, but there is some discovery that can take place. It's cross-examination of witnesses through depositions, for example, that are used as evidence by the parties. And then what you see is the PTAB, this is about 8 or 9 months, the PTAB holds an oral hearing. And this is not like a trial in a district court. At this point, the board has all the arguments and evidence through the briefing. So our hearings are more like what you might see at the Federal Circuit or other circuit arguments where the parties have argued their case based on the existing record at that point. And the point of the hearing is really to make sure that the judges understand their positions. And generally speaking, there are some exceptions, but generally speaking, the parties can't raise new arguments or provide new evidence during the hearing. They have to do that during the briefing part earlier. And generally, we issue a final written decision within 12 months of institution. And one thing to keep in mind is no claim is found can be held unpatentable until we issue that final written decision. Next slide, please. Now, as some of you may have heard, Acting Director Stewart issued a interim process memo on March 26th, so just recently, and it relates to a new bifurcated process for determining whether to institute. And under this new process, decisions on whether to institute a trial are bifurcated into 2 parts. In the first part, the director, in consultation with at least 3 senior judges, will determine whether discretionary denial of institution is inappropriate. And this could be for reasons like whether there are serial petitions or parallel petitions filed under what we call 325D, which is whether the same or substantially the same arguments before the office, or also under FINTIV. And FINTIV takes into account factors as to when there is a co-pending district court litigation and whether that district court might address those issues and get to it before the office will. So in the second part of this bifurcated process, if the director and her team decides that it is not appropriate to discretionary denial, then a board panel will address the merits and other non-discretionary considerations and determine whether to institute. I wanted to flag that we actually, people have had questions on this. We did a board side chat on April 17th. You can see the slides and the videos of that webinar. And we also have frequently asked questions and there's information there that's really great. It's really detailed. It'll get all the nitty gritty of the processes. And those frequently asked questions will control. So you can take a look to sort of understand why it is. But basically the short of it, we won't get in the nitty gritty, but the short of it, if you look here on the slide, you can see there's the timing of the briefing. So basically, within 2 months of the office issuing a notice of accorded filing date, this is when they accord a filing date to the petition. Within 2 months of that, the patent owner may file a discretionary brief in relation to the petition. And then a month later, the petition can file an opposition brief no more than 1 month later after the due date for that. So for example, it corresponds with the due date for the patent owner's preliminary response if they want to file it. And absent good cause, the director will issue a decision on those discretionary considerations within a month of the due date of the last paper. So these process, and then at that point, if, as I mentioned, if the director determines that discretionary denial doesn't apply, then the merits panel will get into the picture and then they'll determine whether to institute. So one thing I did want to say is if you have any questions, in addition to the webinar I talked about, the frequently asked questions, you can email the office at an email address. It's director_discretionary_decisions@uspto.gov. And the website talks about that, how you can ask questions there. So if you go to the next slide. So this shows the details of our entire process from the moment a petition is filed to, if there's institution, to a final written decision. And what you can see in the second phase, if the PTAB actually institutes a trial, that process takes about 12 months. So at the 3-month mark, patent owner files a preliminary response, and if they wish a motion to amend, thereafter there's a series of responsive briefing back and forth. So 3 months later, there's a petitioner reply. A month later, there's a patent owner surreply. There's additional papers if there's a motion to amend. Then we have the oral hearing, as I mentioned. And so, you know, I mentioned a lot of this already about, you know, there's discovery, there's the oral hearing and things like that. So if we go to the next slide. So there's motion practice in our AIA proceedings. And what you see here are common types of motions that happens in AIA proceedings. So you can see motions to have counsel enter a paper to represent a party. This is what we call a pro hoc vice admission. There are motions to seal confidential evidence. There's motions to exclude evidence. There's motions to strike. For example, if arguments in a paper go beyond the scope of a reply. There's motions to amend, there's motions for additional discovery, motions to terminate, and so on. And if you're interested in our motions practice, I did want to flag that we did a great presentation on motions practice. If you go on our website, you can find all of our board side chats. There was one on March 18th, 2021, and it has the webinar and the slides. And it explains all sorts of things about our motions practice, and including things like what's the difference between supplemental information and supplemental evidence and things like that. Next slide. Sources of law and guidance that bind us in AIA proceedings. So similar to all of our proceedings, we're bound by U.S. Supreme Court and Federal Circuit precedent. We're bound by the statutes you see there that govern IPRs and PGRs and other relevant rules. We're bound by PTAB precedential decisions. We also have guidance in the form of our consolidated practice guide. This is also on our website. The most updated version was updated in November 2019. And then also the director can issue guidance and memos that we are also required to follow. Next slide. And there are other federal rules that apply to us. So we're bound by the federal rules of evidence, and this is by our own regulations. It says we're bound by the federal rules of evidence. So this applies to motions to exclude and things like expert testimony. The federal rules of civil procedure do not apply because we have our own rules for discovery. Next slide. So if we go to a final written decision, what happens? What are the possible outcomes? And you can see there, we can uphold all the claims. So all the claims are found patentable. Each and every challenge claims is upheld. There can be a mixed result with at least one claim, but not all are upheld. And then we can find all of the challenge claims unpatentable. I did want to flag for general awareness because some people talk about PTAB stats, if you will, in terms of what happens in a final written decision, and that's it. But remember the rest of the process that we just talked about that the parties go through before we get there. First of all, a party will decide whether to file a petition in the first place. You'll hear, and I mentioned that about 80% of our IPRs have co-pending district court litigation, but it turns out the reverse isn't true. Third-party data indicates that only about 20 to 30% of patents asserted for infringement in district court litigation are actually challenged in AIA petitions at the board. That means that defendants, when they're sued, they're actually strategic about whether they file a petition or not. There's a selection process about whether they even file a petition in the first place. And then after, if an IPR petition is filed, it may or may not be instituted for the reasons I discussed. A case can settle before or after institution. Now, if a case is instituted and it doesn't settle, the board will issue a final written decision determining whether the challenge claims are patentable or not. But it's worth noting that about 40% of the challenged patents are even addressed in a final written decision. And generally over the years, about a third of petitions actually make it that far. I did want to say, if you're interested in our stats, we have a link to it at our USPTO, our PTAB website. You'll see on our homepage, it has a link to statistics. And this also includes some really interesting studies. Like we've done some studies on challenges to Orange Book and biologic patents. We've done studies on our motion to amend pilot and now our rule. And we've also done studies on multiple petition filings and how often that happens and why. So take a look at that if you have a chance. Next slide. And so if there's a final written decision, what are the options for the parties? So the first one is they can seek rehearing by the panel. They can also seek, they can request director review. And this is where the director themselves takes it on. This is following Arthrex, their ability to do that. And for more information about the director review, because that's a whole nother presentation about director review, check out our website. It has great information about the processes. It also has a link that talks about the status of the cases and links to decisions. And then lastly, if the parties, they can do those things or not, but regardless, they can appeal to the Court of Appeals for the Federal Circuit. And I think that is it for me on those.
Well, that may be the end of your section, but I will tell you, and that was great information. But before we head into the next section, we actually have some more questions, and I was hoping we could take this opportunity to get you to answer some of them because they are directly about IPRs. So the first one is, when an IPR is requested by a defendant in a patent infringement case in U.S. District Court, why doesn't the plaintiff have a choice to agree to participate in the IPR or to remain at the court?
Yeah, sure, I can answer that question. So the board is required to file, we have to follow all laws, regulation, and binding agency policy, and this includes statutes such as the American Invents Act. So under the American Invents Act, anyone who's not the patent owner or a government entity has the opportunity to challenge the patentability of the claims. This includes a party who's been sued, for example, as I mentioned. Under current law, if they wish, the parties can settle or their court case. They can do that in the courts, or they can do that at PTAB. Plaintiffs are allowed to drop their complaint in district court if they wish, and either party in an AIA proceeding can request adverse judgment. But under current law, as we're mandated to follow, defendants do not have a choice as to whether they are subject to patent infringement lawsuit by a plaintiff. And similarly, in an AIA proceedings, patent owners don't have a choice as to whether they're subject to an AIA proceeding when somebody files a petition. However, I will point out that the USPTO has developed framework to avoid duplication and harassment of patent owners where there are parallel proceedings in district court and filings here at the board. So under this framework, the USPTO decides whether to use the discretion, the director's discretion to institute or not. And changes to current law need to be made by Congress, but until that time, we are required to follow current binding law.
That's good information. Thank you. Another question for you. During an IPR hearing, does the patent examiner who initially allowed a patent testify as to the validity of the patent, including a baseline of facts about when and why a patent was examined and issued?
So as I mentioned, we're required to follow all laws and regulations and binding agency policy. And under existing legal authority at this time, an examiner who examined the challenge patents doesn't participate in an AI proceeding. And another thing to keep in mind is IPR petitions are often filed by somebody who's been sued in court, and this can occur many years after a patent issued. And the examiner in question may not be available or even at the office any longer. But I did want to point out that both parties have a chance to participate in an oral hearing in an IPR. And as part of that, a party can request live testimony of a witness if they wish, especially if the demeanor of a witness is critical to assessing credibility. Parties don't often ask for this, but it is an option for this. And if you're interested in learning more about that, in our consolidated trial practice guide that I mentioned, which is on our website, you can check out pages 31 to 32. It discusses live testimony and how to request.
Excellent. Thank you so much for addressing those. So now, Chief Judge Bullock, some of the board's priorities have been refocused under the new administration. Could you tell us about some of PTAB's current priorities?
Sure, I'd be happy to do that. As you can see here, so our priorities, first of all, are to execute the duties as required by 35 USC Section 6. That's the part of the statute that sets out the duties of the board to conduct both appeals and trials. And with that in mind, we have a priority to maintain high decisional quality while reducing the pendency of ex parte appeals. Our goal is to decide ex parte appeals within 12 months of the time the board dockets the appeal, with limited exceptions for cases that have good cause or unusual circumstances. But that's sort of our goal, and we are working hard to make sure that the ex parte appeals issue within 12 months of docketing, at the same time continuing to meet all of the statutory deadlines in the AIA proceedings that Deputy Chief Judge Bonilla pointed out. In particular, as you recall, there are two statutory deadlines, one for institution and one if a trial is instituted for the trial phase. We also are looking to make IT improvements, among other things, trying to move our systems into the cloud to help increase resiliency and security, as well as looking for other IT improvements, for the users. Recently, for example, we added new paper types to go along with the new bifurcated institution process that Deputy Chief Bonilla talked about. Also, you can see here just historically, if you look back to the formation of the PTAB at the inventory of appeals, you could see in our early days, we had a large number of ex parte appeals back in the early days. The board worked very hard to bring the overall volume of the inventory down to where you see it today, and currently there are about 4,700 total cases. And then of those cases, again, as I'd mentioned before, we aim to decide them with limited exceptions within 12 months.
Excellent. Well, we're going to now, and we've got a lot of questions. So, and we have a little bit of time remaining on the webinar. So I'm going to stop sharing the slides. And that way, maybe we can just go straight to some of the questions, if that's okay. And first of all, Chief Judge, I have a question for you. How has PTAB been affected by incentives to depart the agency and or the return to office order?
Sure. Well, thank you. So, um, we have had some impact. A number of both the judges and the staff at PTAB have departed based on the incentives or other regular departures or retirements. And of course, keep in mind at the moment, there is a hiring freeze on within the administration. But just as an example, at around January 19th, we had about 350 total members at the board, including about 230 APJs and about 120 support staff, which includes our patent attorneys, law clerks, hearing staff, paneling staff, IT support, paralegals, and other administrative staff. And since that time, about 30 judges and 20 staff members have departed due to a variety of reasons, including some of the incentives or other just regular retirements or resignations to take jobs out in the private sector.
So do we still have sufficient number of judges and staff in order to do the statutory work required of PTAB?
Yes, we do. We currently do have enough staff, and so we can handle both the appeals and the trials with the current judges and staff on board.
Well, Chief, I hate to keep peppering you with questions, but here's another one for you. In an ex parte appeal of a rejection based on lack of patent eligible subject matter, does the PTAB follow the patent eligible guidance in the MPEP, or does it follow federal circuit law?
Well, we hope those two are one and the same. So we do, and in the patent eligibility guidance that former Director Yanku issued, it expressly stated that guidance was binding on the board and the examining corps. Now, the guidance, of course, has been updated over time to add examples and adapt to any current case law within the federal circuit. So I know the team that does that's worked really hard to make sure that there really isn't a gap between the guidance and the federal circuit cases. I would say if in any particular case you think there is one as pertains to your case, I would put that in your brief and put that in your argument. But just say folks work really hard to make sure that those are, in line with each other.
Excellent. Well, Deputy Chief, we are not leaving you out of the questions. In fact, we'd like to know, in regards to the appeal of a re-examined patent, does a third party get an opportunity to submit a pleading?
So I won't go into the nitty gritty. This is about re-exam practice. And basically in ex parte re-exams, a requester can file and they are involved upfront at that stage and generally not after that. I did want to flag that we have some great information about that. We issued a notice. This is on our website too. You can find it. It's a notice that we issued in April of 2019, and it describes options for reissue and re-exam. So I would understand our rules, our case precedent, our trial consolidated trial practice guide. you know, and one thing to note is on our website is we have all of our precedential informative cases there, including the latest ones. So you can go check it out. Our website is great for information. And one of the things you can do too, which I do myself, is sign up for USPTO newsletters and alerts through our USPTO subscription center. And you can sign up by topic. For example, you can sign up and say, I want all the information about PTAB. In terms of advice, I was going to give some advice for patent owners, especially if you're thinking about asserting a patent in litigation. One thing they may want to think about is what they can do to, quote, IPR proof their patent during original prosecution or later in a re-exam or reissue application. So it's important to, you know, really do due diligence and think about the challenges that might come in advance of suing. Sometimes when you go through prosecution, you may or may not have thought of everything or know of everything. Maybe you were doing it with limited funds. So you may want to think about it before you actually sue, because at that point, honestly, you're kicking the hornet's nest because now a lot of money's on the line. So people are you really want to do your diligence and be prepared for that. And with that in mind, don't forget about reissue and re-exam. And I mentioned that April 2019 notice, and it describes options for amending claims through reissue and re-examination. And this can happen before a AIA petition is ever filed. It can happen during an AIA during and after an AIA proceeding. It can even happen, patent owners can file them after patent owner issues a final written decision. So for example, if you get an unfavorable decision, but you know, hey, maybe those claims had a problem, but I know I can amend those claims to get around them, you have the option of going through reissue and re-exam to do that. The other thing I would mention is during prosecution, you know, I understand sometimes funds are limited, but the best you can do to do your own prior searches and engage in active discussions with the examiner. Don't hide your weakest positions from the examiners. You really want to get that out there. And you also want to flesh out if you have any evidence of secondary considerations during prosecution, such as commercial sales, copying, long felt need, industry praise, and then the issue of nexus between the evidence and the claimed invention. That's something if you can put it during prosecution, it's really helpful. And I say that because we have this jurisprudence under the statute, which is 35 USC 325D. And that basically says that we can deny an IPR if the same or substantially the same arguments and art have been before the office and the examiner didn't err. And so if you get that stuff before the office and you make sure it's cleared up, you could potentially get a denial of an IPR if somebody tries to raise the same stuff. Another point I would make, and this, I think this is obvious to most people, but make sure you get a full scope of the claim covering any commercial product of yours or a possible competitor. So when claims are found unpatentable, whether it's anywhere in the office, it's generally because the scope is too broad, but not because the inventors didn't actually have an unpatentable invention there. So make sure you get the broad to the narrow going to your commercial product. And lastly, I just want to say that applicants can control how long prosecution takes. They can do it really quickly. For example, if they don't take any extensions and they take advantage of programs like the fast track appeal pilot. And I wanted to flag that because before the PTAB right now, if you want to file an ex parte appeal, you can actually fast track it. You can basically pay a petition fee. It's nominal. I think it's like $400, something like that. And you get a jump ahead of the line. And then we will, under that pilot, we will decide your ex parte appeal in under 6 months. And we've put a limit on how many people can do that. But honestly, we've come nowhere near that limit. So that option is available. And right now, under that pilot, we're actually deciding our ex parte appeals in about 2 to 3 months. So if you want it to happen fast, you can. Oops.
Hopefully you can hear me. Sorry. That was great advice. Chief Judge, we have a couple of questions for you. First, reject a PTAB's decision on ex parte appeal and refuse to allow a patent to issue?
Yeah, so I guess what I would say to that question is, the examiner, when they get the case back after the PTAB has overturned their rejection, the examiner can go back and find, for example, additional references. It's I would think it's rare to not do any additional work, but they can bolster the rejection in further prosecution, or they can withdraw those rejections that were overturned, but enter new rejections and continue prosecution that way. Although I will say, and we did a study on this some years ago, turns out in the vast majority of the cases, if the examiner is reversed, it's likely the next step will be an allowance. But there are a certain percentage of cases where prosecution continues under different rejections. So it won't be the exact same, but the examiner has some freedom to either supplement or add new rejections going forward. So there can be a continuation after a reversal.
Very good. I know that we're closing in on the end of the hour, but we do want to squeeze in one last question, if that's okay. Specifically for you, Chief, can a patent applicant amend their claims in order to satisfy a rejection by the examiner in the appeal brief itself?
Right. So the amendment should be done in front of the examiner. In fact, if you have an examiner's rejection and you want to amend, the way to do that would be more for continuing prosecution, or setting up an interview with the examiner to discuss if you have a hint of what amendment will overcome the rejection. But if there's an amendment unresolved, the board doesn't rule on unentered amendments in an appeal. It's essentially we look at what the examiner has done, and the applicant needs to point out what they think is an error in the examiner's work. So entering amendments is something that needs to be done by the examiner in prosecution. I say that stands a little bit in contrast to what happens in AIA trials. So I could see where there may be some confusion. As Deputy Chief Judge Bonilla mentioned, in trials, the board will evaluate amendments in a trial proceeding, but only in trial proceedings. In appeals, it's done by the examiner.
Excellent. Thank you so much. Now, I know that we have come up to the end of our hour and the close of this webinar, but I just want to say thank you very much, Chief Judge Bullock and Deputy Chief Bonilla. Thank you for spending this time with us. Thank you for giving us all of this fantastic information and for answering our questions. And I'd also like to thank everybody who joined us in the audience today. As a reminder, a recording of this video will be posted on the USPTO's webinar webpage on the events page. So thank you, everyone, and have a great rest of your day.